Hello. This is another session of Ask the Attorney. Before we continue, I'd like you to go to the first video in terms of our disclaimer and how this video does not create an attorney-client privilege relationship. Today's question is from Stephen in Ontario. He says, "Dear Attorney Chang, I'm a low-level employee in a big construction company. To work here, I'm required to sign a contract that says if I am quit or am fired, I cannot work in the industry for the next 5 years. I think that this is really unreasonable, but really want this job. What do I do?" Well, let me tell you, Stephen, in California, it's a little bit different from other states. Business and Professions Code 16600 basically does not encourage these type of agreements. In fact, it says that every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. And what that essentially means is contracts that restrict movement in terms of profession are absolutely void in California. Now, there is a caveat to that, and that is for higher level employees, for those that are CEOs, things of that nature. What contracts have a tendency to do is to get around this by allowing in a provision in regard to trade secrets and how an individual cannot be able to take the trade secrets from one company to another. Let me give you an example. Let's say you were a truck driver for Coca-Cola. Well, you can work for Pepsi the next week. That's not going to be a problem because you're not subjected to trade secrets. However, if you are a high-level employee CEO, such as the CEO of Coca-Cola, and you wanted to move over to Pepsi, indeed, the contract that restricts your movements in regard to trade secrets would be enforced. And lastly, if the conditions of your employment require you to sign a contract like this, that is illegal and is subject to a potential lawsuit, and the employer could be liable for doing that. Thank you very much. I look forward to hearing from you again. Thanks.